Welcome back to the Law and Crime Network. I'm Heather Hansen, and we're continuing to watch clips from last week's testimony in the Solinder case as we get ready for the court to come back in the case against George Burch. I have with me my fellow host, Aaron Keller, who's got a little bit of insight into this Burch case, given that you used to be a reporter up in that area. Did you run into any of the players in this case while you were there?
Yeah, I mean, it's a small area. Now, everybody knows about Green Bay because there's an NFL team that just happens to be there, but it's an area that's not terribly transient. Okay, it's not like Orlando, Florida, where people come and go all the time. It tends to be the same people. They just move around the chain. So, for instance, the judge used to be the prosecuting attorney, the district attorney in that area, John Zukowski. I used to interview him frequently when I was a reporter up there. Very fair. That was my impression of him. Very soft-spoken compared to some other attorneys, and he, at least the impression that I had of him was that he was very worried about being fair and making sure that if there was going to be a conviction, that it was a fair conviction under the law.
And that's nice when it's a process. I mean, now he's wearing a judge's hat, which makes it very reassuring that, especially in this case, I was talking to Julie Rendelman before you came in today about this case being rife with legal issues and motions for this judge to decide. It's not a very straightforward case. There's the Fitbit information that we've discussed a little bit this morning, but a lot of motions to preclude evidence, which makes a judge's job tough. And so it sounds like he's going to really work to decide each and every motion in the most fair way possible.
That's relatively common from what I remember of covering cases in Wisconsin. There is a lot more pretrial evidence jockeying in that state than I see in other states, for instance, Florida. Wisconsin, again, from my perspective, and maybe it's just the cases that I follow, just tended to be a very heavy motion in limine sort of state. A lot of using of the rules of evidence to get this piece in, try to get that piece out.
Yeah.
And the practice, pretrial practice, really focuses on that in Wisconsin. In Florida, for instance, it focuses on depositions in a lot of cases because Florida allows depositions before a criminal trial. Not every state does.
Right.
So every state has its own little unique way that the pretrial process tends to play out. I think that that's relatively accurate from what I recall of Wisconsin.
Yeah, it is, as you said, it's interesting, and it's all strategic. Those pretrial motions may sound like, oh, just motion practice, and a lot of times the younger partners or the younger associates are responsible for drafting those motions, if not arguing them, but they can make or break a case. Like in this case, the Fitbit testimony and evidence that will get in is they will allow the Fitbit evidence with regards to step walked by Doug Detry, who is the boyfriend of the victim who was originally accused of this crime, but not whether or not he was sleeping at the time of the crime. That's important for both sides. Had none of the Fitbit testimony gotten in, the prosecution would have a very different case and a much more difficult case to prove. But given that they were able to get at least some of it in, it certainly helps their case. Had they been able to get in both the steps and the sleeping, even stronger for the prosecution. So these motions aren't just throwaway something for people to do before trial starts. They're pretty major.
They are, exactly. I mean, you basically argued your own point and then answered it, but I'll react to it. Yes, that's exactly the way these things go out. The whole point of a motion in limine is to get a piece of evidence answered as to relevance, admissibility before the trial. Of course, you could object to it in the midst of a trial, but why take that risk? Get it dealt with on the front end, and in many states, and I think Wisconsin included, that's the way many lawyers I've observed practice, if not most, if not all.
Yeah, the interesting part of this too is once you've got a motion in limine decided, you've then got to be careful as a lawyer to make sure that your witnesses know the rulings. Because if they don't, and they not even on purpose, but mistakenly blurt out something that the judge has said is not to be part of this case, you've got a mistrial. So for example, this Fitbit expert has to be well prepared to talk about the steps, but not mention the sleep issue. Because if he or she does get into, well, the Fitbit also showed that he was sleeping, the defense could move for a mistrial and likely get that granted because the judge has already said that is not fair game.
Either that or the judge could just tell the jury to disregard it, because my experience, and again, I never watched a trial in front of Judge Zukowski because when I was there he was a prosecutor, but I also tend to see judges push things towards a final jury verdict, and then if somebody complains about it on the back end, well, the appeals court can determine whether or not it was a big issue or a little issue.
Right. I've seen both happen. I have seen mistrials when, and not only that, but mistrials that then led to, so a case is trying, Oh, and it looks like we're back in the Burch case, so we'll have to finish this conversation a little later. In the meantime, Aaron, I'm going to go right back to the courtroom. Welcome back to the Law and Crime Network. I'm Heather Hansen, and we are taking many breaks because the tech in that courtroom for George Burch is just not all that we want it to be. Aaron, do you think it's the weather? The weather there is certainly an issue.
It could be, and keep in mind, Brown County, Wisconsin is got a beautiful old historic courthouse. It is one of the most solidly built buildings in the city.
Right.
Perhaps a bank vault would be thicker, but this thing has impenetrable walls.
Well, and what does that mean for us?
It means that the signal oftentimes can't get out of the room.
Right,
That's the trick. And not only that, but the way that the setup is in this courtroom, I've been in this courtroom before personally. There's a separate media room in the back of it, so the reporters can't even put transmitters near the windows, which oftentimes helps because they're back in a separate room,
yes,
which makes it even harder to push a signal out.
And it's not like this is super compelling testimony right now. We've heard from police officer after police officer after police officer. Do you think that this is A, a strategy, or B, just a scheduling issue to sort of, because normally we like to see when we're watching these cases, what seems to be most compelling to juries is to have a very strong witness as your first witness. And here the first witness was people who discovered the bodies. Now we've heard from a bunch of police officers who were involved in the investigation. Why not call one, Doug Detry or Nikki's sister? Somebody who's really going to, because remember, this is a jury trial. It's not a bench trial. Is that something that is sort of idiosyncratic to that area, or do you think that it's just simply the way the prosecutor wants to put his case in?
I was thinking the same thing, and I can't put my finger on the answer because in the cases that I remember the victims' friends and family and relatives going relatively early in the case. I'm trying to remember if I covered one that didn't quite play out that way, and I'm drawing a blank. Keep in mind it's been more than 10 years since I lived up there, so I can't remember literally everything play out.
Yeah, I mean, it just hasn't been that compelling, and then going in and out. I think that for now, I'd like to sort of switch our focus to some of the other cases that we're covering. And fortunately, President's Day, so that's the only case that's going today, but tomorrow, we've got a full day here. We've got the Sollander case, which we've been looking at clips of throughout the course of today. Mm-hmm. We also have Donald Smith starting back up tomorrow with the death penalty phase of his case. What are you expecting there, Aaron? Do you think that we'll hear from Donald? Do you think we'll hear from his family members? And what do you think the defense is going to try to do to save his life?
I mean, what's he got to lose at this point? Is he going to give an allocution, which would allow him to basically say something without having to be cross-examined? I don't know if Florida allows that. Some states do. But look, that's a case that if there's going to be a death verdict, it seems relatively certain.
Right. That's what I was talking with Julie about this morning, because, we've seen now Nicholas Cruz has been in and out of court over the past few days, accused of the premeditated murder of those 17 students in Parkland. He too is in Florida. He too arguably will face the death penalty. And so for me, looking at the Donald Smith case becomes even more interesting, because I agree, if any defendant that we've ever seen is going to get the death penalty, I would think it would be Donald Smith.
And I'm not saying whether I agree or disagree with the death penalty. And I think that you're saying the same thing. It's just, as lawyers, we have to sort of predict the likelihood of something. And in this one, I think everybody can predict the likelihood of a jury coming back with a precious 8-year-old child being killed and raped as the evidence piled on top of evidence on top of evidence proved happened.
And the lack of remorse from the jailhouse recording. I mean, for me, that would be, without exaggeration, the nail in the coffin. No matter what you think of the death penalty, if you are if you're meant to be applying the law to the facts, and the death penalty is legal in Florida, though it has to be by a unanimous jury, it's going to be interesting to watch and see what happens there, and how the defense tries to make it a compelling case that he shouldn't be put to death given all of the evidence against him.
I'm really curious to see how the defense tries to word that, because I would struggle to come up with the words, I have to admit. I am not licensed in death penalty jurisdictions. Well, actually I am, but in the jurisdiction where I am, it would have to be the murder of a public servant, a police officer, something like that. Not in, a first-degree murder victim. It would have to be special circumstances.
Right.
And even then, where I'm licensed, it's rarely ever applied, because that kind of crime rarely ever happens. So I'm curious to see how they're going to try to push this, if they're going to try to, say that it would waste money? I mean, where would they go with it?
Well,
I'm struggling to come up with the language.
Yeah, I mean, Julie was saying today that they may try to argue that it's a sickness that did this and not he that did this. But I feel like a lot of that is a double-edged sword, because if it's a sickness and you believe that it's a sickness, then clearly he's been unable to be rehabilitated in his other stays in jail if that gets in. And so I think for some people, it would be more reason to have the death penalty be appropriate, because this man's incapable.
Yeah, look, and if that past starts to come in now at this penalty phase, then the jury already probably loathes that particular defendant. This is not going to endear him to them.
Right, right. Now let's talk a little bit about, I do want to remind our audience that we will be covering the Donald Smith death penalty phase of that case starting tomorrow, and that's certainly for many of us one to watch. I know many of you are very interested in that. What I do also want to talk about, though, with you, Aaron, is the Solinger case, because I know that you were here Friday for much of the compelling testimony from the nanny. I also know that you, during the coverage of the War Machine, got into conversations with the prosecutor, and she's the same prosecutor as in that case. What do you think is going to be the most compelling piece of that case, and what did you think of that defense attorney? I thought his opening was quite good.
Well, look, the defense is going to have to characterize what happened in that case somehow, and the defense has a couple of different cards it seems to be playing. Mm-hmm. One is characterizing that maybe some of what was done wasn't really that bad. Maybe it was exaggerated by this defendant who wrote the book, which we just showed you. You got a defendant who wrote a book about adoption and child care who's now accused of 46 counts involving adoption and child care.
Yeah.
So, I think that the defense is trying to play a couple different cards. They're trying to say, okay, some of this isn't as bad as these children exaggerated it to be when it was reported. And the defense is also trying to say, some of you witnesses who are talking smack about the defendant, in other words, only saw slivers of what went on. And so if the defense is able to inject some doubt by saying, okay, you heard, witness, that this really bad thing happened, but you didn't hear what led to that thing, and you don't understand how much of a struggle it is to be a parent in this kind of a situation. And I think that seems to be the way the defense is going. But look, you have attorneys on both sides who are very passionate, and they're really duking it out over this case. And the characterization of it, look, the defense is doing its job properly.
Yeah, it's and I do think that he was very effective in his opening. I do think that the prosecution's objections with regards to him slipping into argument and talking about some things that the evidence not only showed, it's difficult for lawyers, because in your opening statement it's supposed to be just an outline, very dispassionate, just really setting forth what the facts will show. But sometimes what the facts will show is up for debate, and sometimes you get into that debate in your opening and step into what should be a closing argument. And it seems like he did so, but perhaps not on purpose, and was a little bit frustrated by his inability to sort of go there. But I thought in toto, it was a very good opening statement. And what makes me think that, other than the fact that, in talking to people, a lot of people that I spoke to, that as the case started and they had read about it, felt like she was pretty much done, after his opening statement thought, you know what? He might have a case.
And look, then that's a great opening statement, because the whole point of it is to get the jury's mind to open up bit after having heard a pretty nasty indictment. Okay? And that's the whole point of it.
That's right.
I mean, it's great if the defense can spin a completely different counter narrative, but look, I mean, the reality is that if there is a completely different counter narrative, chances are it's not going to go to trial, unless the prosecutor is ridiculously overzealous, which I don't think is the case here.
Right.
There's a difference between being fair and being overzealous. Prosecutors, as a matter of ethics, under the rules of professional conduct, aren't supposed to just go file charges against anybody that they think they can get something to at least stick, like a Post-it note, firmness. They have to have the super glue firmness to go after the case. You can't bring the charges unless you think you're going to get a conviction beyond a reasonable doubt.
Aaron, what do you think about the fact that the other players in this case took plea deals? Do you think that it plays into the case in any way? And if so, how? I originally thought that perhaps she would try to attribute the most abhorrent of the abuse to her partner, her husband. But we haven't sort of seen that in the openings anyway.
Well, it'll be interesting to see how it plays out, and I don't know the answer to this, and somebody out there probably does, and I'll probably get corrected on it, but I'll pose it because I don't know the answer. There's no marital privilege in Nevada child abuse cases.
Right.
Okay, so are we going to see one of these other previous co-defendants up on the stand saying something about her? Could they be forced to say it? What would they do if they were forced to say it?
Well, it seems as though they could be forced to say it if there's no privilege.
Yeah, I mean, they could be called to testify, but then was that worked into a previous plea deal? And even then, would the prosecutor call that witness, or does the prosecutor know that that person would be a lousy witness and possibly covering for this defendant? You know, there's got to have been a lot of background behind the scenes wrangling over that we don't know the answer to sitting here, but part of me would love to be a fly on the wall on that, because the co-defendants were the husband and the defendant's daughter.
Right. Yeah,
so,
and you're absolutely right. If they want to protect her, they could really hurt the prosecution's case if it's part of the deal. And even if it's part of the deal, they could hurt the prosecution's case. You know, so if we do hear from those people, I agree with you, that could be some really compelling testimony.
You know, what happens if one of those witnesses, one of those previous co-defendants who has copped a plea, gets up there and says, it was all me, it wasn't her.
Right.
Then what? I mean, you know, the prosecutor probably did some pretty serious weighing as to whether or not good testimony or unhelpful testimony would come out of some of these other people. I'm sure that that had to have been worked into the plea.
Right. I mean, we saw that in that case out of Boston with the young girl who was killed and the mother testified against her boyfriend. And part of the plea was contingent on the testimony, and sometimes it's even contingent on the conviction. You know, the plea deals can be sort of crafted in all sorts of ways. So this plea deal, we don't have the ins and outs of the plea deals with the husband or the daughter, but they certainly may speak to any testimony, what that testimony would look like, and what that testimony's effect might be. And so you're right. I think that's something that we definitely need to watch for and listen for as we go forward in this really interesting case, which is going to pick back up tomorrow at the same time as Donald Smith.
We have a lot going on. We have this case out of Green Bay that's getting national attention. You've got questions about the Fitbit data, questions about how well that's going to play out, whether it's accurate or not.
Yeah, we have a lot going on, and we're going to take you right now to continue with the clips we've been playing in Solinger. This is one of the social workers who was involved with the family. When we come back, Aaron will be sitting in this case talking to you more about these cases, and I'll be back tomorrow. Have a good day.